for course development, but the schedule is quite packed. So I'm glad Mark is okay, and maybe it's a blessing we have extra time to create our course curriculum. So Ansel needs a couple of minutes, but what I'll do, can I introduce you now? So I'll introduce Professor Ansel Brown is a ISGAP fellow. He's been associated with ISGAP for many years. He's a visiting assistant professor at North Carolina Central University at the School of Law in North Carolina. And today he's going to speak about examining common libels against the Jewish state under international law. And Ansel's been working in this space for many years, so I'm sure it'll be a great lecture. I'm glad you're here. Are you ready, or you need more time? Yeah, you ready? Okay, cool. All right, great. So good morning, Ansel. The floor is yours. Thank you for being here.
All right, thank you, Charles. Well, good morning, everyone. As Charles mentioned, my name is Ansel Brown, and I will be deconstructing with you today some of the common libels against the Jewish state under international law. Now, to give some context to what I'll be sharing with you today, I teach, as Charles referenced, a seminar in international law at the law school, and in the summer of 2023, just a few months leading up to October 7th, when I was teaching the international law course for our law school, in the class, I was frankly taken aback when we got to the portion of the course addressing international humanitarian law. Thank you. What I noticed was that there was a pronounced disdain by many of our students for the state of Israel, in an unsettling and impassioned zeal that was more than the normal intellectual exchange that you might expect in the classroom. It was almost as though the students who come from institutions from all over the country had been corporately indoctrinated into these adverse positions on Israel. It is my belief that these libels against Israel have been meticulously woven into the psyche of our universities, and that the vitriol against the Jewish state is not random, but in fact it is well orchestrated and highly coordinated. Now, I will not get so much into this today, but I want to simply lay the context for what we are seeing in the academy as it relates to these libels that are being lobbed against the Jewish state. So let me give a quick overview of the accusations or libels that we are going to be deconstructing today. The first libel is that Israel is an illegal occupying power. The second libel is that Israel is a racist apartheid state. Next, Israel is committing genocide. This is one of the more grotesque libels that we're seeing as of recent. And finally, the libel that Israel is a serial impediment to peace. So I want to begin by addressing the libel that Israel is an illegal occupying power under international law. Now, notice that I am calling this more than just an allegation, but expressly a libel. Because if we pay close attention to the allegation, it actually conjures up the most dangerous tropes of Jew hatred, stereotyping, and demonization of the Jewish people. It fits the bill of classic anti-Semitism, simply rearing its ugly head in a modern slander against the Jewish collective of Israel. Imagine the likely universal condemnation we would hope to see if a statesman or stateswoman were to stand up before the United Nations General Assembly and assert that there must be a global effort to curtail the sinister power of Jewish tycoons who are using their power to steal money from the weak and vulnerable populations of the world. Now, as outrageous as this may sound, if we stop and think about it, the accusation that the Jewish collective of Israel is an illegal occupying power encroaching the stolen lands of a weak and defenseless population in contravention of global norms is no different in essence than this hypothetical scenario. And what makes this a libel is that it is deeply damaging and patently offensive, which we will be outlining today. So there are essentially three fundamental conventions of international law upon which this accusation stands. That's United Nations Security Council Resolution 242. That's the pre-1967 armistice line between Israel and Jordan that actually is the 1948 armistice line. And that's the Fourth Geneva Convention protecting civilians during wartime. So let's start with Resolution 242, the resolution that was passed just after the 1967 war that was instigated against Israel by surrounding and hostile Arab neighbors. By the way, hopefully we are entering into a new era where these hostilities will begin to abate with the advancement of the Abraham Accords. But yet still, one of the primary obstacles to the advancement of this reality of peace and mutual prosperity in the region is the accusation that Israel is illegally occupying Arab lands in contravention or in violation of United Nations Security Council Resolution 242. So if we look at the language of Resolution 242 and essentially examine it with a legal lens, we see that this accusation that Israel is in violation of 242 is unfounded. So let's take a look at the language. 242 reads that it calls for the establishment of a just and lasting peace in the Middle East, which should include the application of both the following principles. Notice the word both, because what that means is that both Provision 1 and Provision 2 are part and parcel. They come together, right? You cannot separate the two. And so the first provision here calls for withdrawal of Israel armed forces from territories occupied in the recent conflict. And we're going to come back to this. The second provision of 242 calls for the termination of all claims or states of belligerency and respect for and acknowledgement of the sovereignty, territorial integrity, and political independence of every state in the area, and their right to live in peace within secure and recognized boundaries free from threats or acts of force. So when we look at the first provision of 242, and you see this map here, the areas highlighted in beige are those areas that were captured by Israel in the 1967 Six-Day War. And so looking at Provision 1, the requirement of withdrawal of Israel armed forces from territories occupied in the recent conflict would seem to suggest, at first glance, and what is asserted by many of those positing that Israel is in violation of international law here, is that 242 in this first provision requires Israel to withdraw from all of the areas that we see in beige. However, we must ask the question, what is meant by territories? Again, this is our legal, careful analysis of the language. And the example that I like to use when I'm explaining this to students is, let's suppose we're on the playground and I am the playground bully. And I have $3 of lunch money and you have $3 of lunch money. And I try to take your $3. And you win that spat and you acquire my $3. Okay, so you now have $6 and I have none. So we find our way into the principal's office and the principal says, okay, the way that we're going to resolve this dispute between Ansel and the other party is that the other party must return money to Ansel. Okay? Now, if the other party is required to return money to Ansel, how much do you think the other person is going to return? All $3? No, simply money. $1, $2. So if we take this analogy and we apply it to Resolution 242, Israel is not required to return the territories, or going to the analogy, the money, which would mean all of the money or all of the territories. Israel is required under 242 to return territories. And this language was carefully crafted by the authors of 242. So Israel is required to return territories to the extent that Israel still can live in peace with secure and recognized boundaries, free from threats or acts of force. And what we see is that with the 1979 Camp David Accords, culminating in 1982 with the full Israeli withdrawal from the Sinai Peninsula, that this is exactly what Israel did. It gave back 2/3 of all of the territories that were seized in the 67 war. So it gave back $2 of the $3, right? So Israel, in fact, is in compliance with Resolution 242. Next, what you often hear is that Israel is somehow required under international law to return to the pre-1967-1948 armistice line. Well, as diligent readers of the language of the armistice line, we simply need to go to the language of the armistice agreement and see what is the plain language and plain reading of the agreement. And it says expressly, no provision of this agreement shall in any way prejudice the rights, claims, and positions of either party hereto in the peaceful settlement of the Palestine questions. The provisions of this agreement being dictated exclusively by military considerations. The armistice demarcation line defined in Article 5 and 6 of this agreement are agreed upon by the parties without prejudice to future territorial settlements or boundary lines or to the claims of either party relating thereto. So does the armistice agreement establish a political boundary? The clear, plain reading of the agreement itself is that it absolutely does not. Israel is not required to return to these lines that were solely a military truce or a military consideration by the plain reading of the armistice agreement. Next, the Fourth Geneva Convention. And this is often cited as a basis for the allegation or accusation that Israeli communities in the territory of Judea and Samaria, or what the world calls the West Bank, is a violation of international law. You often hear the illegal Israeli settlements. And this is where that language or that accusation comes from. It comes from the Fourth Geneva Convention. Well, let's look at the convention itself. It reads, the convention shall apply to all cases of partial or total occupation of the territory of a high contracting party, even if the said occupation meets with no armed resistance. So we see here what is the general application of this requirement, okay? Where does it apply? And then it goes on that the occupying power shall not deport or transfer parts of its own civilian population into the territory it occupies. So we see the application again of the Fourth Geneva Convention is where we have the occupation of the territory of a high contracting party. Now, for those who are not lawyers, you may ask the question, what is a high contracting party? Because this is where this convention comes into play. Well, if you think about any type of legal contract or agreement, the contracting parties are the signatories to the agreement, right? And so in the Fourth Geneva Convention, who would be the signatories to the agreement? State actors, states, right? High contracting parties are states. So when we look at the territories of Judea and Samaria, we ask the question, prior to 1967, who was the high contracting party? Who was the state? Was it Jordan? Jordan occupied this territory from 1948 to 1967, less than 20 years. It's not Jordan. There is no high contracting party. There is no state whose territory is being occupied. And even if one were to take the argument that somehow there is this theoretical future wishful state of Palestine whose land would be occupied, we then have to ask ourselves the question, is Israel an occupying power? And so what I like to do in answering this question and addressing the idea of Israel being an occupying power, particularly when I'm engaging with my students, is I don't begin with 1967. I don't begin with the 48 War of Independence. I don't begin with the 1947 UN partition plan. I don't begin with the 1917 Balfour Declaration or even the efforts of Theodore Herzl and the modern Zionists to advance Zionism. I say that we must look at the contextual history of the nation of Israel because it goes back at least 3,500 years. Whether one accepts the historical veracity of the biblical stories of Abraham, Isaac, and Jacob, Joseph, and others, the historical and archaeological record is clear, and it clearly establishes that the Jewish people emerged in the Levant at least by 1400 BCE, and that the United Kingdom of Israel was consummated with Jerusalem as its capital by 1000 BCE. Further, the Jewish people have maintained a consistent presence in the land, in spite of intermittent dispersions and foreign occupiers attempting to rebrand the land of Israel. Israel is not an occupying power, either in violation of international law or by normative human common sense and decency. A people with 3,500 years of unbroken connection and a history of political sovereignty in a land where there's been no other sovereign political entity confined to that land cannot be called anything less than indigenous and rightfully in their homeland. Now I want to next turn to the libel that Israel is an apartheid state. I'm not going to spend too much time on this particular libel today, but I'm going to simply make three important distinctions that demonstrate profoundly that Israel is not an apartheid state, as many have compared to apartheid South Africa. Also, in previous lectures on this topic, I have drawn from the expertise of our dear friend, our beloved sister, and a champion of Israel, Olga Michaud Washington, who sadly we recently lost. May her memory be a blessing. And so before I continue, I would like to take a brief moment of silence to remember our dear sister, Olga. Thank you. So the first distinction that I would like to draw here is that in South Africa, there was a foreign invasion by Europeans into the homelands of black South Africans, where blacks were subordinated by European colonizers who sought to impose a reality of supremacy over the local population. And as we have established, the Jewish people are indigenous to the land of Israel with an unbroken presence and heritage in the land. At minimum, there has been a legitimate dispute between two indigenous groups in the land. But more true to reality, the Jewish people have simply reclaimed their homeland that was previously supplanted by others. The second distinction. In South Africa, there was complete social segregation and civic alienation of black South Africans. In Israel, its 20% Arab population fully participates in the social fabric of Israeli society and has full civil rights, including serving in the Israeli government with even the freedom to oppose the state of Israel. Now, however problematic that may be politically speaking, this is a civil right that is freely enjoyed by Israeli Arabs. Furthermore, the Israeli Jewish population of the Jewish population in Israel, the majority did not immigrate from Europe or the Americas. But the Jews who are in Israel, the majority are either those whose grandparents have been in Israel for centuries or who returned to their homeland from Asia and Africa. The third distinction here that I would like to make is an important distinction, because people may argue that even if we accept that the Jewish people are indigenous in the land of Israel, and even if Israeli Arabs enjoy full civil rights, the status of Palestinian Arabs is what, sort of that analogy is what would make Israel an apartheid state akin to apartheid South Africa. But here there is a major and significant distinction of moral and legal weight that must be drawn. The status of Arabs in the territories is 100% the result of Israel's self-defense to protect the Jewish state against persistent Arab aggression to eradicate the Jewish people from their homeland. This is by no means what black South Africans attempted with European colonizers, although they in fact had every right to legitimate resistance against this real colonization. Black South Africans were not trying to eradicate the British from Great Britain. They were not trying to eradicate the Dutch from the Netherlands. They were not even trying to eradicate Europeans from living peacefully in South Africa. And when we look at Israel, to the contrary, every olive branch that Israel has extended to Arabs residing in the heart of the Jewish homeland of Judea and Samaria has been met with genocidal aggression and brutality. It is an insult to black Africans to demean their legitimate struggle against European colonialism and neocolonialism by comparing it to the illegitimate aggression and rejectionism of the Palestinian leadership backed largely by the population. Next, on this note, let's pivot to the deeply problematic actions of the ANC leading a global chorus of leftists and Islamists in accusing Israel of genocide before the International Court of Justice. By the way, we must critically note that the ANC does not represent the views of all South Africans, and it certainly does not represent all Africans around the world. Indeed, when South Africa brought the accusation, specifically the ANC, I should say, of genocide against Israel in December of 2023, it was the Ugandan Justice, Julius Subatinde, who alone stood with the Israeli appointee, the ad hoc appointee to the court, Aharon Barak, in dissenting against the ruling of the court. Okay? It's an important note that I want to make. So let's talk a little bit about the context of the Geneva Convention. Here, the Genocide Convention specifically, that was used as the basis of this accusation. Now, importantly, the context of the convention is that it was created in 1948. at the same time or during the same year as the creation of Israel. And as you might imagine, the context of this is that it was a post-Holocaust creation in international law to prevent another Holocaust. So the idea of wielding this post-Holocaust creation in international law to prevent another Holocaust against the Jewish state of Israel evokes none else but Holocaust denial, victim blaming, and victim shaming. And I just want to highlight that in previous eras, when the world seemed to be more theologically oriented, aggression against the Jewish people was backed by the accusation of deicide. And now, in a more humanistic world, the Jewish people are being accused of the evil of genocide. Okay, so let's now actually look at the legal definition of genocide under international law. If we read the Geneva Convention, it says that in the present convention, genocide means any of the following acts committed with intent to destroy, in whole or in part, a national, ethnical, racial, or religious group as such. And it delineates the examples of acts committed in furtherance of the intent to commit genocide. So what we see here, I have bracketed, is two legal concepts that we see oftentimes in criminal law, and it applies here with the international crime of genocide, is that we see both a requirement of what we call actus reus, or a guilty act, and mens reus, a guilty mind. So both are required, both a guilty act backed by a guilty mind or evil or guilty intention. So, South Africa, or the ANC, made 7 primary factual or actus reus type accusations against Israel before the ICJ. And we will go through each of these and unpack them. Let me begin by saying, before we work through these, that the loss of any life is tragic, okay? And the need for war is always a human tragedy. And I am not positing here that Israel has made no mistakes or missteps, because Israel is not perfect, just like every other nation and country in the world. But I am asserting that in its campaign of self-defense in Gaza, Israel is not guilty of genocide. So let's look at the first accusation. The first accusation is that Israel is killing large numbers of Palestinians in Gaza. Well, the Palestinian population overall has increased from 5.5 million on October 8th of 2023 to today, 5.7 million. Where's the genocide? The population is actually increasing. And of the estimated 42,000 collateral civilian deaths in Gaza, this constitutes 1.8% of the 2.3 million Gazans on October 8th of 2023. And again, we are not making light the loss of any innocent civilian life. But I'll just note that this number is 0.5% of the 6 million Jews who died in the Holocaust, who, unlike what we're seeing in this present conflict, 67% of all European Jewry, or 2/3 of all European Jewry, died in the Holocaust. This number that we've seen in Gaza is 5% of the 800,000 Tutsis who died in the Rwandan genocide. It is 14% of the 307,000 Syrians who died at the hands of Bashar al-Assad's massacre of his own population. Where was the moral outrage in Syria? Is it that there is silent racism, that Jews are held to a higher moral standard than their Arab counterparts? Or is it simply outright anti-Semitism? It is likely a bit of both. The next accusation. Large numbers of Palestinians are reported to have been wounded, the majority being women and children. Well, the number of civilian injuries in Gaza is actually comparable. The number is very close, almost identical to the same number of injured civilians in Afghanistan. And there was no global outcry or accusation of genocide in the self-defensive war of Afghanistan. And in fact was endorsed by the United Nations Security Council and backed by both the right and the left politically. The next accusation. There has been a mass expulsion from homes and the displacement of Palestinians in Gaza. And so here there is a fundamental common sense counter to this argument. But for the evacuations, the number and wounded in Gaza would be exponentially higher. Full stop. Okay? The next accusation. The deprivation of access to adequate food and water to Palestinians in Gaza. The truth is that 7.3 million tons of aid and 15,207 trucks have gone into the Gaza Strip since the war began, and only 1.5% of that has been denied. And of course, we know that Hamas is hijacking much of the aid that actually reaches the area of Gaza Strip with the intention of going to the people. The next accusation. The deprivation of adequate medical assistance to Palestinians in Gaza. The truth? 18,400 tons of medical supplies have gone into the Gaza Strip. Next, attacks on Gaza's medical health care system. This is the next accusation that was made before the ICJ. Well, we know that Hamas uses these facilities as medical human shields. And finally, the accusation of the destruction of Palestinian life in Gaza, meaning housing, hospitals, schools, mosques, and other infrastructure. Well, the estimated 160,000 structures that have been destroyed during this recent conflict compares to over 1 million structures that were destroyed in both Syria and Iraq. Okay, so I'm not saying any of this is good, but again, we are seeing a gross double standard when dealing with the Jewish state here. Finally, let's discuss the legal concept of mens res, or the guilty mind. And so under this requirement, under the Genocide Convention, there must be the guilty mind or the guilty intention, or what the Genocide Convention alludes to as the intent to commit genocide, okay? So we must ask ourselves, has the Israeli government intended to destroy, in whole or in part, a national, ethnical, racial, or religious group? And the evidence pointed to of Benjamin Netanyahu's statements that is sort of the basis of this accusation that Israel intended to commit genocide is telling. So a couple of excerpts here that were referenced in the petition that was presented to the ICJ is that Benjamin Netanyahu's statement that we are striking our enemies with unprecedented might to defeat the bloodthirsty monsters who have risen against Israel to destroy us. And then further, you must remember what Amalek has done to you, says our Holy Bible, and we do remember. So we ask, who are the enemies and monsters? Who is Amalek referenced here? Is it a national, ethnical, or religious group? No, it's Hamas, who themselves committed an act of genocide against the people of Israel on October 7th and remained committed to carrying out this genocide. And so here the paradox is that the very international law that was designed to protect the Jewish people from another Holocaust is now being wielded by the enemies of the Jewish people to prevent them from defending themselves against another Holocaust. This is not only legally errant, but is deeply and morally twisted. And just briefly concerning the ICC arrest warrants against Benjamin Netanyahu and Yoav Gallant, these accusations fall under international humanitarian law, also governed by the Geneva Conventions. And without getting into the nitty-gritty of that, the basic premise of the relevant humanitarian law is that civilians are protected in military conflict. And so a couple of exculpatory notes that I want to point out here is, first of all, that combatants have an obligation to distinguish themselves from civilians by wearing uniforms or a distinctive sign or by carrying their weapons openly. So I ask the question, does Hamas do this? Absolutely not. Second, international humanitarian law acknowledges that there will be collateral damage in conflict. And it acknowledges proportionality, as long as the military objectives are distinguished from the civilian objectives. And the value of the military objective is proportionate to the threat to civilians. So Israel is on firm footing as it relates to the concept of proportionality. Also note that international humanitarian law prohibits the use of human shields. And the International Red Cross puts forward that parties using human shields assume responsibility for the civilian injuries. And human shields should not be calculated into the proportionality equation so as not to incentivize the use of human shields. So we see here that Israel is not in violation of the laws of conflict or international humanitarian law pursuant to the faulty ICC warrants against Netanyahu and Gallant. Next, I want to turn to the libel that Israel is an impediment to peace. This is the final libel that I want to address. And the truth is that Israel is on, again, sound legal footing in international law in both its existence and its efforts to make peace in a hostile and antagonistic environment. So, of course, we know that in the wake of the First World War, the British seized control of the area that became known as Palestine, that had previously been occupied by the Ottomans. And pursuant to the British control of this land, the region of Palestine, in 1917, we saw the Balfour Declaration promising the entirety of this land, which included what is Israel today, the territories, and the present state of Jordan, as a promise to the Jewish people as a homeland. Now, one may say, can a foreign power deed over land to a nation, right? Is the Balfour Declaration legitimate? Well, let's look at international law again. In 1922, the global community, by way of the League of Nations, affirmed, right, the Balfour Declaration. In the language of the League of Nations resolution, is recognition has hereby been given to the historical connection of the Jewish people with Palestine and to the grounds for reconstituting their national home in that country. So this was recognized not just by the British, but by the international community in international law. And then, of course, we saw the partitioning of this homeland promised to the Jewish people in 1922. with the sort of reduction of the mandate for Palestine by 77%, going to the emirate of Transjordan, right? So we see, in my view, here the creation of the first and what I believe should be the last Palestinian homeland of Jordan, okay? And then in 1937, there was another commission promising a Jewish state, the 1937 Peel Commission. And then we saw another partition in 1947. There were pogroms by the local Arab population against the Jewish population in Israel at that time. And so eventually, the United Nations came up with another partition plan in 1947. Who accepted the partition plan? The Jews accepted the partition plan. Who rejected it? The Arabs rejected the partition plan. And then, of course, in 1949, the United Nations recognized the state of Israel. I want to point to just a couple of important texts here in the Palestinian National Charter of 1964, nearly 2 decades after the creation of Israel. And we can see who is resisting and impeding peace. In Article 17 of the Palestinian National Charter, it reads, the partitioning of Palestine, which took place in 1947, it's not referencing Israel declaring statehood, it's referencing the 1947 UN partition plan. And the establishment of Israel are illegal and null and void. This is the Palestinian National Charter. Article 18, the claims of historic and spiritual ties between Jews and Palestine are not in agreement with the facts of history or with the true basis of sound statehood. And then just a few years later, we see the same sentiment being echoed by aggressive nations that attacked Israel in the 1967 war. Nasser and Egypt. The problem before the Arab countries is how to exterminate the state of Israel for all time. Aref in Iraq states, our goal is clear, to wipe Israel off the map. The president of Algeria, the Arab struggle must lead to the liquidation of Israel. Damascus government radio, throw them into the sea. Fast forward to the 1979 Camp David Accords that I alluded to earlier. What did we see as a result of Israel ceding, again, 2/3 of all of the territories back to Egypt? We saw the first Intifada and the creation of Hamas in 1987. What happened once Israel ceded more territory with the Camp David negotiations or the Oslo Accords? We saw the second Intifada in 2000 and the spate of horrific suicide attacks against Israeli citizens. 2005, again, of course, we know the Gaza disengagement, the complete evacuation of Israelis from the Gaza Strip, and the removal of all Israeli military presence in the Gaza Strip. What did we see? The 2007, first of all, the election of Hamas to power, and then the 2007 Hamas seizure of power, ultimately culminating, of course, in the October 7th massacre of 1,200 or more Israelis. Today, Israel proper, as some would say, is on 21% of the original land that was promised in the Balfour Declaration that was recognized by the international community by way of the League of Nations resolution. Bill Clinton's words are prominent. He stated after the failure of the Camp David negotiations that Yasser Arafat's reluctance, coupled with his open support for the Second Intifada, led Israel to give up on negotiations. Finally, Zionism. Is it a peace impediment or is it a justice movement? In the words of the renowned Pan-Africanist and civil rights leader W.E.B. Du Bois, he stated, the African movement means to us what the Jewish or the Zionist movement must mean to the Jews. These are the words of W.E.B. Du Bois. And then finally, the founder of modern Zionism, not Zionism in its totality, that goes back 3,500 years, but the founder of modern Zionism, or the leader, champion of modern Zionism, Theodor Herzl, he draw a deep parallel between the Jewish struggle of Zionism and the African struggle, in the words of the term that was used in that time period to reference blacks or Africans. He stated in his book, there is still one problem of racial misfortune unresolved. The depths of that problem and all their horror only a Jew can fathom. I mean the Negro problem. Think of the hair-raising horrors of the slave trade. Human beings, because their skins are black, are stolen, carried off, and sold. Now that I've lived to see the restoration of the Jews, I should like to pave the way for the restoration of the Negro. Thank you very much, and I welcome your questions. Yes, sure.
Thank you very much. Thank you for your tour de force. Thank you. Any comments or questions? Gila.
Thank you so much. As Charles said, it was tour de force. I just have one little question about the Balfour Declaration and what happened after that when the British did not allow Jews to reach Israel during the Holocaust. Were they violating international law, given what you said about Balfour Declaration? Or was it just a change in their policy that kind of negated the Balfour Declaration? It's a specific question about international law in Britain in the 40s, in the 30s.
Okay, so just for clarity, are you asking were the British in violation of international law, or were? Okay, yeah. So no, the British were not in violation of international law. They secured the British Mandate Palestine as a result of World War I, which is normative in international law for a country that secures, a certain territory in a legitimate conflict to then administer, the legal realities in that territory. So it was not a violation of international law. And as I noted, that declaration was recognized by the international community by way of the League of Nations resolution in 1922. That would not have happened if the British were in violation of international law with the Balfour Declaration.
The question is whether they were violating international law in 1940, for example, when they did not allow Jews to come to Israel.
Oh, okay, I see. Oh, I follow you, yeah. Yeah, that's an interesting question, and I think that's worth research. You've come up with a great
that was the white paper?
Yeah. I think that's an interesting concept, and it is possible that they may have been in violation, given that the international community had recognized the right of the Jewish people to establish a homeland in what was British Mandate Palestine. Is that the denial of that right that was secured under international law was in fact in contravention of what international law had recognized by way of the League of Nations resolution. So that's a very important point. I think it's something that again warrants further exploration. Thank you.
Thank you so much. This is more of like a semantic question, but I think it's important just for context and interpretation. So when you talked about international humanitarian law and defining collateral damage and proportionality, how are those defined, and then who actually gets to define that? Is there like a collective vote on how those are interpreted? How does that work?
Yeah. So, excuse me. Unlike what we see in domestic law, where you have courts with binding rulings such as ultimately the Supreme Court in the United States, excuse me, in international law, largely what is normative in sort of solidifying international law is the voluntary compliance of sovereign states in the international community. And so it's a bit amorphous and unlike what we're familiar with in domestic law, but it's essentially by way of assent by the international community. And then, of course, you do have some entities like the International Criminal Court that can file, arrest warrants for those who may be in violation of committing war crimes. Now, it should be noted that all nations are not signatories to the ICC. And the reason that the ICC was actually created not too long ago was for the very point that I mentioned, that in international law, it largely relies upon the assent of sovereign nations, and there is not this overarching sort of binding political or judicial entity, I should say, unless the sovereign states concede to ceding some of their sovereignty over to such an entity.
So in that case, how do we know what actually constitutes proportional or collateral damage? Because, is it like percentage of population? Is it, because when you talk about retaliation, like what is considered a proportional attack, what is considered like a normative or acceptable collateral damage, depending on, the status of the state, whether or not they're a member, you know what I mean? So is there some oversight for that, or is it really just based on international acceptance of, oh, this seems appropriate, we'll allow it, you know what I mean?
Yeah.
There's some legal guidance for that?
Yeah, well, unfortunately, one of the sort of ambiguities of international law, it is the latter, right, to a large extent, right? It's kind of like this sort of a normative acceptance of or interpretation of what constitutes proportionality. Again, there are entities such as the International Criminal Court, but again, it does not have jurisdiction over every nation. So it is a bit hazy, but without, again, digging into the minutia here, if you examine Israel's actions in Gaza, again, not saying that Israel is above reproach, every nation makes missteps, but by and large, Israel is not committing war crimes in the Gaza Strip by definition of the humanitarian law that I referenced.
Also, Michael Walzer wrote some interesting stuff on this. Michael Walzer wrote some interesting things on this.
There you go.
Michael Walzer wrote some interesting things on this.
Thank you very much. Dr. Small, you said Michael Walzer, but which book?
He wrote articles on proportionality.
On proportionality, okay. So thank you very much for your presentation, Professor Brown. Our hearts are with you. It's so beautiful to see people arguing in a coherent and legalistic manner on these matters, because all we hear is hearsay and the public sphere. So my questions are twofold. One is on the letter on Amalek, with a quotation from the Bible that Netanyahu sent to the soldiers, which at least on the face value, if it indeed included the fragment or kill all women and children and ass and or don't spare anyone. And the other is, I read somewhere, so forgive me not being too specific on this, but I read somewhere a letter by article by a lawyer about the Viennese Convention or Vienna Convention, which talks about that diplomats of the countries that carry out their official duties cannot be stopped from doing so. And the general notion, I thought, of this kind of international justice being served in terms of genocide and so forth, accusation of genocide or war crimes, is that it is only, the process is only carried out if the countries
themselves are not able to carry out justice, or don't have democratic institutions and so forth, like Hamas. Yes, we know there was never any process in Palestine whatsoever concerning Hamas's war crimes or their soldiers' war crimes and so forth. So this kind of twofold. Could you tell something more about the letter on Amalek, whether it constitutes of face value, at least the actus mens, and the Viennese Convention, or the context of why the supposed war crimes should be left to Israeli democratic institutions that are independent from the government? Thank you.
Okay, thank you. Concerning your first comment, the reference to Amalek was honestly taken out of context. Netanyahu's reference was basically to what has been sort of recognized throughout Jewish history as a symbol of antagonism and bigotry and hatred and the sworn enemies to the eradication of the Jewish people throughout history. That is what is meant by Amalek. And Netanyahu was not, again, alluding to any intention to eradicate men, women, children, donkeys, etc. in the Gaza Strip, but he was referencing Hamas, which had genocidal intentions, and they still have genocidal intentions. And this is the spirit of Amalek that Netanyahu was pointing out, was completely taken out of context. And so to your second point, I'm not sure I quite understood the question, but I will make a point that may touch it or not. And that is that we must remember that Hamas is the democratically elected governing entity in the Gaza Strip. Okay, so we're not talking about a non-state actor here, right? Now, they're not a state, I should say, but we're not talking about a non-political actor, I should say, or like a rogue entity. This was the elected, again, government of the Palestinian people in the territories. And so, again, Hamas, in my view, is in fact guilty of genocide under the alluded to convention as a political actor.
Thank you so much for your presentation. Dozens of countries have recognized the Palestinian state. Canada, France, and the UK are all weighing doing so in the coming months. So I have a few questions. Number one, would this change anything with regards to the application of international law to the conflict? Number two, are there any legal responsibilities that come with the recognition of a Palestinian state to Hamas or the PA? And number three, what is the point of recognizing a Palestinian state? Thank you.
What was your last comment?
What's the point of recognizing a Palestinian state? Like, why are these countries doing it, kind of thing?
Okay, so just for clarification, as far as the legal repercussions of some of these states independently recognizing a Palestinian state is that it really doesn't carry any force under international law. I mean, Charles can recognize Quebec as a state, but that doesn't make it a state, right? What is required to recognize or for a state to actually sort of carry some sort of legal substance in international law is that the United Nations Security Council recognizes it. And so whether Canada or UK or France or whomever recognizes a Palestinian state, it does not mean that there is in fact an internationally established Palestinian state with legal repercussions. And so the point of it, recognizing if it doesn't carry that sort of legal weight, is that it's political. It applies political pressure on Israel in the international arena, and unfortunately and tragically, it rewards Hamas for committing a massacre and, again, a genocide against the Jewish people on October 7th of 2023.
So, Amy?
I appreciate that last exchange very much. I agree it's political. Do you think that it has the potential to tear apart the European Union when you have a founding member state such as France arguing that an organization that you acknowledge is a governing power and the 27 left EU states recognize that power as a terrorist organization, to then have the founding member state, France, recognize nonetheless that that should be a state, that inevitably for them there'll be such blowback for the entire polity that we recognize as a transnational polity of the European Union?
Yeah, thank you for that question, Amy. I don't have a crystal ball. I'm not a prophet. I can't look into the future. I'm not sure if it would tear apart the European Union, but I think it would certainly create a fissure because there's certainly not a consensus within the European Union on recognizing a Palestinian state. And it really goes to a deeper question of the EU polity of sort of individual state foreign policy and the collective policy of the European Union together. And to your point, these kinds of issues could ultimately create the kind of fissures within the cohesiveness of the European Union that you're referencing. But whether it will actually happen or materialize, who knows? But it could. It's a possibility.
Thank you so much. As you pointed out very clearly, for the establishment of the genocide accusation, that there should be clear intent, right? That is the most important requirement for the genocide, for that to be genocide. And this is clearly a weaponization of international law because there is no genocidal intent on the part of Israel. But even they seem to realize that the accusations cannot hold. So now there is a different kind of intellectual current, namely genocide studies, to get rid of the notion of intent altogether and to broaden the genocide concept way beyond what we knew from international law. And what they are referring to such concepts, they construct concepts such as cumulative radicalization, meaning that even if there was no preconceived intent to commit genocide during the course of the war, Israel actually radicalized its action as much as it is actually committing genocide. So the question is that beyond the weaponization of international law, that there can be a broader weaponization that is going way beyond law and legal discourse. This could have an impact largely on how people see Israel and the Gaza war, and it may also have some kind of impact on international law. Thank you.
I'll just add that the idea of removing intent from a crime is a ridiculous notion, both in international law or any law for that matter. I mean, imagine, walking in the subway, tripping and bumping into someone else who falls into a passing subway, and you're convicted for first-degree murder, right? If you remove intent, right? It makes no sense.
Manslaughter.
Yeah.
Professor, could you speak to one legal point that's in international law that's mystifying to an outsider? I can't figure out how the ICJ uses precedent in their judgment of these kinds of things. And throughout the Cold War, accusations of genocide in violation of international law were ubiquitous, but never had any kind of substance to it beyond the initial political conflict. I didn't say the Soviet Union was sometimes correct in decrying aggression or so, but what they called a precedent, it was just kind of made up, and I don't see where precedent is coming into these judgments.
Well, that's right, because the International Court of Justice, the way it's set up and its authority, actually it does not have precedent. It's on a case-by-case basis. So they may look at previous opinions or decisions as useful in the administration or the sort of drafting of a current decision, but there is not binding precedent for the International Court of Justice. It's on a case-by-case basis. That's why.
Just one quick follow-up. Can that be used then to say that these judgments are arbitrary?
I won't say the judgments are arbitrary. They are binding upon the parties who go before the court for that particular case. But the decision today is not binding on the court for another case that comes before it tomorrow.
Ifat?
Hi, good morning. Thank you for this interesting presentation. I wanted to ask, first of all, to challenge ourselves with the issue of genocide, because you were pertaining to the specific warrant that was issued against Netanyahu, saying there's no way that he intends to do that. But there are a few ministers in the government of Israel who say things that look very much like that. And this is a new challenge for us. Like, I'm talking about us, liberals from Israel who are fully against this weaponization of international law. We're legal scholars. We're, it's hypocritical. It's frustrating from a legal standpoint when you talk about Israel as a whole, or even about Netanyahu. But if you look aside a bit to the way some of the ministries are expressing their thoughts about what's happening in Gaza, I think there's a new challenge here. Like, is there a way of distinguishing their talks from, what happens on the ground? Because, like, our sons are in the army, and we know exactly how that works there. They are the complete opposite of, they do the complete opposite of that. The head of the Attorney General for the Army is a good friend of mine. I know how hard she works, and her whole team, tirelessly to make sure that there are no war crimes, not even sporadic war crimes going unnoticed or happening as much as she can. So this would be one thing. And the other is that I wanted, and Oti, do you want to add to that as well? And then?
Just please.
I did it the whole week, and now you came, you see, as Israelis, we are much more critical of our government, which makes sense. We talk about it a lot here. But it's not only ministers, the leading ministers, and some of them are in the very small a cabinet that decides on the war. It's not like, member of parliament. And you have to consider also the political context in Israel, the charge against Netanyahu, with criminal charges, which many of us believe that that's why these ministers have much more effect on him than they had been if he hadn't have this criminal charge. And I think it's a huge challenge for us as Israelis, but also, for the intent issue of the genocide. And a second point that is not really related to that directly, but to say that not only there is not apartheid in Israel, but the main and most extensively financed affirmative action programs in Israel are made and dedicated for Arab Israelis. So you were presenting they have equal access, Supreme Court justice, and so on and so forth, but there's also the issue of affirmative action, which is really very strongly targeting this specific population. It's important to say, especially in higher education.
Well, thank you for adding that point to the points that I made. And concerning your question concerning the rhetoric of some of those in the Israeli cabinet, whether it has an effect on the decision-making of Netanyahu or the military echelon is subjective. Who knows, right? Only he knows the extent that that is sort of dispositive and moving the needle in his own mind and calculation. But we have to ask the question then is, are those statements, is that rhetoric authoritative? and binding upon the Israeli government in international law, and I would put forward that it is not. Any rogue member of a government or a cabinet could say anything, but is that authoritative again in what is happening on the ground? And I would again say that it is not, and therefore.
What's happening on the ground is highly relevant. That's what you're saying.
What is happening on the ground is relevant, but what I'm saying is that the rhetoric of those who are speaking of their own accord as representatives in the government, but are not actually giving the authoritative commands, are not. That would not necessarily be binding upon Israel and international law.
Thank you, Professor. 2 points in that question. I think that your analysis in your last slide about Zionism, about W. Du Bois, I think that most African Americans are unaware that Du Bois made that statement. And I would say that most people of African descent are unaware of Theodore Herzl's quote. There are 50 million African Americans. There's 1 billion people of African descent. I think we have to do a better job of informing and raising the level of consciousness. Number 2, your distinction between occupation and indigenous, I think is very, very important. In the outside of the legal arena, there is no mention of indigenous. It's all about occupation. So I think we have a lot of homework to do. And then lastly, outside of law schools, outside of legal firms, outside of courthouses, outside of the International Criminal Court, and I would say outside of the United Nations, because the United Nations voted to make Zionism racism. So, there's conflicting view of not only what is the international law, but what basis how international law gets established. It seems to me that nations that have great power in the Security Council, and I think that I would not underestimate when France and other nations that have major play at the United Nations, declared that Israel is committing genocide. I just don't think that that can be ignored, not so much in the courts, but on the streets. I think there are millions of people right now here in Europe, millions of people in America, all over the world, who have misinformation, been misinformed, but on the other hand, not given the substance of what you have presented. Not trying to put too much weight on you, but I'm just saying that we have to do better, I would say, Charles, to make sure that the narrative is about the truth and not so much the narrative is about all the falsehoods, the myths, the stereotypes. And I think that a lot of times when people are libeled, your whole presentation is about libel. In my view, I'm not a lawyer, but if somebody's liable, we should be taking them to court. It's a violation. A libel is a violation of rights. And you've given a long list of how Israel is being, the Jewish people have been libeled. What do we do about it?
Briefly, answer briefly.
Yeah, thank you so much, Dr. Chavis, and I absolutely agree that we have much work to do because there is what is happening in the military arena, there's what's happening in the political arena, but then there's what's happening in the arena of public opinion. And what we do in churches and schools and synagogues and community civic centers and on the streets really is critical in this effort. And I would say that we should explore legal measures that can be taken to pursue the libel that we are seeing happen. We can't continue to just take a defensive posture, but we need to be proactive, to your point. And thank you for making that point.
Mr. Rabbi, and then if we can, sorry, a very concise question because we're out of time, and then Larry, very concise. We'll collect 2 questions and then yours. Sure. Okay. Thank you.
Thank you so much. Great presentation. I want to build on the question of the legal scholars. How might determining mens res of a liberal democracy, as opposed to the authoritarian governments more commonly cited in genocide, be different from, in other words, in a liberal democracies, whose statement constitutes evidence of mens res, as opposed to an authoritarian government where you can point to the top and say, there's the mens res.
And then Larry, very quickly.
Just one thing.
Well, thank you. That's fine. Larry wants to.
Well, you're welcome, Larry. Thank you. Yeah.
Or you want to do Anthony?
Oh, yeah, sure, yeah.
But Anthony, very concise, please.
Just in relation to going back to the statements that were mentioned by our Israeli colleagues, by Smotrich and Gavir, in addition to that, there's been evidence in the last couple of days that's come out about that we've basically been misinformed about the levels of aid, and that in fact the situation on the ground might have been far more dire. In the context of those statements, do you think it's reasonable for international liberal governments to be concerned that perhaps they need to take the genocide rhetoric more seriously? And I think, and that perhaps there may be a little bit playing devil's advocate of legitimacy in validating the view that you need to look at cumulative surrounding actions to infer intent rather than other things. I think that the sort of dovetail to that would be that that there is this problem of actually it's probably too long. I'll come up to you in the break for keeping it concise. That's fine.
I think those are both similar comments, so I'll respond to them in one answer. I think whether we're dealing with a dictatorship or whether we're looking at a liberal democratic democracy, and to your point, I think we have to look at the official policy of the government. However, the policy is generated, whether by, unilaterally by one person at the top or by a democratic process or by rhetoric in a cabinet. I think in international law, the more sure measure is what is the official government policy at the end of the day.
So I just want to make a brief comment, and then we'll thank Ansel. So I'm having, I guess they're scattered thoughts, but listening to your lecture, which was amazing, as I said, a tour de force. I had these images in my mind as you were speaking, and I was thinking of progressive people in Victoria, British Columbia, calling for the eradication of the state of Israel. Intellectuals in New England, calling for, I don't know, the end of Zionism. You have these characters in colonial states who are speaking about ending the state that is so profoundly justified, biblically, historically, politically, from all these international organizations, et cetera, and then we're still, in a way, in this onslaught of anti-Semitism, which focuses on Jewish peoplehood. We have to figure out ways to justify our existence. So, I'm not a legal scholar, but in terms of the discourse, I find it fascinating that we still, the Jewish people still, have to, constantly defend our right to exist. If it was under the guise of religion or under the guise of race, and now under the guise of sovereignty, national sovereignty, it's incredible. Ruth Weiss, Professor Emeritus from Harvard, has a very strong opinion on this. We interviewed her for JBS, and she said that the Jewish people should just, for the hell of it, we shouldn't be even defending ourselves anymore and just get on with it. And the people who question our sovereignty and our legitimacy are anti-Semitic, and she has some strong words. And then Another thought that came to mind the other day, I recommended looking at the lyrics of Leonard Cohen's song, The Future. And what came to mind today is Bob Dylan's Neighborhood Bully. So if anybody wants to Google the lyrics to Neighborhood Bully, I think it's also, as only Dylan and Cohen could do, they really, nail it on the head. So, in light of that, obviously everybody really appreciated your work, and thank you for being here, and really thanks for your wisdom and insights.
Thank you so
And
much.
multidimensional insights.